My name is JonBenet Ramsey, and I'm 5.5.
Our investigation reveals that not a single leak was true. There was no snow on the paths around the house. No handwriting expert has ever concluded that Patsy Ramsey wrote the ransom note. John Ramsey did not leave his home that morning, nor did he fly his family back to Atlanta, nor was any pornography found.
Hello and welcome to True Crime Rocket Science, the most authentic voice in true crime. This is episode 13 in the conceded series. What you've just heard is an audio clip from The Killing of JonBenet, The Truth Uncovered, which came out around about the 5th of September 2016. I'd say about half of those statements are probably untrue. First of all, it wasn't clear that there was no snow. And we're going to look in this episode for how and why you can make the grand statement. Let's play it back again.
No handwriting expert has ever concluded that Patsy Ramsey wrote the ransom note.
And of course you've got to qualify that and say, well, someone who they decided wasn't an expert did conclude that Patsy wrote the ransom note. So, one way to turn water into wine is to, for example, take an expert and say, well, we're not going to allow your testimony because we don't accept or we don't admit your credibility, right? And I must say in this particular area, one feels frustration at what feels like a somewhat chaotic prosecutor, a somewhat erratic prosecutor, a prosecutor who feels a little bit disorganized. When I narrated the 22nd and final chapter of The Craven Silence earlier today, I came across a quote that is just under the chapter, and it is from Craig Silverman, a former prosecutor, and this is what he said about the Ramsey case. He said, "By checking out pedophiles in the area, the prosecution is conceding the main point of the Ramseys, that there was an intruder. Once you have conceded the possibility of an intruder, I don't see how any Ramsey could ever be successfully prosecuted," end quote. Now, this turns on its head that whole idea that the Ramseys said where, wow, investigate us, but once you're done with that, then go and investigate all the other likely suspects. And so it sort of turns on its head this whole idea that the Boulder police fixated on them. And I think Silverman makes quite a good case here that what the Boulder police probably should have done was basically, for a very short period, looked at the likely witnesses, so perhaps the housekeeper, perhaps the guy who was working at Access Graphics, one or two people, and then not look any further from that point onwards, just focus on the Ramseys. It's kind of a difficult tightrope to walk, isn't it? Because if you don't look at any of the other suspects, you can be accused of being biased, which is what Carnes seems to be suggesting, and which is what obviously the Ramseys suggest as well. But Craig Silverman does make a very good point. If you're conceding the possibility of an intruder, then you're already shooting yourself in the foot. And isn't that what happened here? And you think about it just from a legal perspective, where a legal case is being made that could an intruder be involved. If you're conceding that possibility, then you open a can of worms, and isn't that essentially what happened? The can of worms was opened, and then from there, the can of worms becomes, wow, the handwriting of this ransom note isn't Patsy Ramsey's. Do you see where it can end up? Now, in this episode, I want to deal with the legal problem of trying to solve this conundrum. So we've got to put our lawyer caps on and think about some of the nomenclature of the legal concepts that handwriting experts would use, and some of the legal issues faced by the prosecutors, lawyers, and the judge in this particular case. Before we get to that, if you haven't subscribed to the channel, please do like, share, leave a comment, and let's get started. So we are going through what feels like old territory. It does seem like most of the Khan's order, or much of the Khan's order, is dominated by a kind of effort to dismiss some of the handwriting experts and give credibility to others. But it does show you that perhaps the bulk of the Khan's order is dedicated to, firstly, deciding whether or not to trust the ransom note as legitimate, meaning that Patsy didn't write it, and number two, giving credence to Loosemith's intruder theory, right? And I don't think you can have the one with the other. I don't think you can really go into the area of the intruder theory without giving the ransom note a kind of a license to say, well, we don't know who wrote it, kind of thing. To be honest, I'm not sure what is more absurd, the idea that a intruder wrote the ransom note, or that the intruder theory is supposedly a credible theory. But in a weird way, if you can take both together, then you end up with something that's sort of half credible. And that somehow the lawyers did turn water into wine, didn't they? So now I'm going to look into page 36 of the Khan's order, dealing with the history of the case. And just speaking of pages, I've just finished narrating the Craven Silence audiobook. So it is up, the complete audiobook is up on Patreon. You can listen to the complete audiobook. I think it's 190 pages long, 22 chapters, and I do think I saved some of the best material for the end. I must say the last 2-3 chapters are pretty incredible what comes out in them. So if you're interested in catching the audiobook version of the Craven Silence, head on to www.patreon.com/tcrs. Okay, so back to the Khan's order. On page 36, she says, plaintiff filed suit on May 11th, 2000, alleging intentional infliction of emotional distress. Now, what's interesting about that date is it's around about a month and a half after the Ramseys went on to Larry King. I think they went on to Larry King in March. So it's basically April goes by and another half of a month. And so that was when their book started entering the circulation, right? Now, this is why I say it feels like the prosecutor, in this case Don A. Hoffman, was a little bit erratic, a bit disorganized, and you'll see why in a moment. So they first allege the intentional infliction of emotional distress, but then Wolf amends his complaint on June 15, so a month later, to add claims for libel and slander stemming from the book and from comments made by Mr. Ramsey on NBC's Today Show. Then she goes on to say, Mr. Wolf has stipulated that he is a limited public figure. On February 9, 2001, the court denied the defendant's motion to dismiss, meaning the court denied the Ramseys' motion to just dismiss the suit. After discovery ended, plaintiff withdrew his claim for intentional infliction of emotional distress. Now, what I do think is possible here, and possibly even likely, is that when this case was made, when this suit was not dismissed, I think that granted Don A. Hoffman access to the discovery, the Ramsey discovery, which in turn seemed to be something that would give Benita Sowers access to some fairly confidential information, right? And that is how the Benita papers came about. Does that make sense? Interestingly, after the discovery ended, the plaintiff withdrew his claim for intentional infliction of emotional distress. This is why I say there's to some extent an erratic prosecution going on. It's not very organized. The libel and slander claims still remain, and that is going to be the subject of episode 14 in this series. On August 30th, 2002, defendants filed the present motion for summary judgment. There are also other motions currently pending. Defendants filed a motion in the mean to exclude the testimony of Sina Wong and Gideon Epstein as plaintiffs' experts. Now, just in plain language, it means the Ramseys filed a motion in the mean, which basically means it's sort of a trial within a trial, right? When you talk about in the mean, it's sort of a separate court case. It's almost like a sub-court case to determine whether you're going to allow certain evidence to be led or certain experts to lead certain evidence. Now, I think the best way to argue against, for example, the handwriting expert saying, I think Patsy wrote the ransom note, the best way, because I mean, you could have one expert saying, well, I think that letter looks like Patsy's handwriting, and another expert saying, no, I don't think so. And then the one expert saying, well, you know, Patsy wouldn't use this kind of style or whatever, and the other expert, instead of having that sort of tit for tat thing, you make things a lot easier for yourself and you just dismiss the experts. So by dismissing the experts, you dismiss the argument, right? And it's because of that, because they successfully did that. The narrative today is that, well, what you heard at the beginning was that no handwriting expert has associated Patsy with a ransom note. And I think most people who know this case know that that is basically BS. Making a grand kind of a absolute statement like that, right? But of course, Judge Carnes, you know what happened with her. She accepted the arguments put in front of her and accepted that Patsy didn't write the ransom note. It seems crazy to us, but this is an example of a legal process happening and it not going the way perhaps some of us would like. Then she goes on to say, on the same day, defendants also moved for oral argument on defendant's motion for summary judgment. Okay, so I'm just going to skim through a little bit further here. We go to page 37. It discusses the motion in limine to exclude testimony, and this is really trying to exclude the testimony of Sina Wong and Gideon Epstein, two witnesses proffered by the plaintiff as forensic document examiners. And then they say, for the reasons discussed below, the court concludes that the defendant's motion should be granted, meaning Sina Wong's testimony should be excluded and denied in terms of Gideon Epstein. So they were basically just letting one expert through the door, right? And then there's an interesting thing called the Dawbert principle, which is an attempt by the court to try to apply scientific methods to rules of evidence, to say, well, you can accept certain evidence if it's factual, if it's logical, right? And so let's just go through some of this. It says, the rule states in relevant part that if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. Now, it makes you wonder, why on earth would you exclude Sina Wong? Didn't she have the knowledge? Didn't she have the experience? Didn't she have the education? What is wrong here, right? It goes on to say the testimony is the product of reliable principles and the witness has applied the principles and methods reliably to the facts of the case. It goes on to say the trial court must act as a gatekeeper and determine at the outset whether the purported expert is qualified. Now, I've sat in on trials. I've certainly witnessed in terms of the Oscar Pistorius trial where you had an expert for the Oscar Pistorius side talking about sounds and whatnot. And I remember the prosecutor saying something like, what did you use to record the audio or the acoustics? What equipment did you use? And the expert answered, my lady, I used my ears. You also had some crazy ballistics testimony that was similarly kind of just unreliable. But I think all of us have sort of come across every now and then an expert at trial where you sort of roll your eyes and you sort of wonder, where did they get hold of this guy? The Khan's order goes on to say, in performing this gatekeeping responsibility, the Supreme Court has articulated 4 factors the court may consider. Whether a theory or technique can or has been tested. I don't think I'm actually going to go through all of this, but it's just various ways that they decide whether or not to use an expert's testimony. Is it relevant? Is it reliable? Does it have a factual basis, etc., etc.? So I'm just going to go now to B, background on handwriting analysis. Defendants argue that the opinions of plaintiff's expert should not be admitted because the field of forensic document examination is not sufficiently reliable. So, what I think possibly might be missing here is some kind of response from Dana Hoffman saying, well, we actually also need to attack the credibility of your handwriting experts. But who knows, perhaps they were, the expertise was unchallengeable. If that is the case, then it's a pity Dana Hoffman didn't spend a bit more time just getting the kind of experts that would be beyond reproach. But I think, if I remember correctly, and I think it is something that I raised earlier, is the fact that they were struggling to get handwriting experts because the quote-unquote best experts had been recruited, and now you're going to be in the shadow of that expert, and you don't really want to jeopardize your career by pronouncing against another expert. Does that make sense? So in that way, it's possible Dana Hoffman, and it was difficult to recruit experts that were credible and that were going to pass the test, kind of thing. I just think it's a pity. Perhaps she just should have tried harder. She goes on to say, in examining defendant's contention, the court notes that both parties agree that the field of forensic document examination, and that now we're on page 40, is premised on the assumption that no two persons' handwriting is exactly alike. Instead, each person has a unique handwriting pattern that allows the person to be identified through a comparison of proper handwriting specimens. Now, you might say that the judge was right, that Sina Wong's handwriting analysis should have been thrown out. What is interesting is that the media have quite often quoted Sina Wong. They've looked at what she said, and she sounds pretty knowledgeable. When she shows similarities, you don't get the feeling that it's fanciful. It makes sense. What she's saying makes sense. So you've kind of got to ask yourself, well, why, on what basis did they throw out her assessment? And this is going to give you some idea about that. Forensic document examination involves the subjective analysis and assessment of writing characteristics. So if you just think about what we're talking about here, is you've got a bunch of experts giving their subjective analysis on handwriting, right? And those experts are said, well, they're credible. It's subjective analysis, but that's credible. Then you've got somebody else giving their subjective analysis, but oh no, that's not credible. And it goes on to say, and assessment of writing characteristics found in a person's handwriting or handprinting style, minute qualities of movement such as pen lifts, shading, pressure, and letter forms. Handwriting identification is an inexact endeavor that cannot boast absolute certainty in all cases. Now, that I think is also quite important to bear in mind. So if you want to call the bluff of the handwriting experts and you say, okay, so they can't be 100% sure that it's not Patsy's handwriting, that they can be like 95% sure it's not her handwriting. If you had a handwriting expert saying that he was sure that it was someone's handwriting, let's say Patsy's, he could also not say with a 100% certainty, just because you cannot do that. because it's an inexact science. So you can say your strongest statement of certainty would be to say, I'm extremely confident that it's this person's handwriting, but of course we can't be absolutely sure, right? So in other words, you can be 99% sure or 90% sure, whatever, or strongly certain that it's a particular person's handwriting. Two or more handwriting experts can reach different conclusions of authorship even when examining the same question document and handwriting exemplars. Then it goes on referring to guild-type apprenticeships, and the only recognized organization for accrediting forensic document examiners is the American Board of Forensic Document Examiners. And you can go through this on and on, all of this, and then you think about when the Ramseys took their lie detector test. I mean, the gold standard for lie detector or polygraph tests are, when the FBI conduct them. So why did they then, and it's also a subjective science, sometimes called a pseudoscience, why did they not go through the proper channels, right? We're now on page 41. I'm going through this fairly quickly. The common terms used within the field of handwriting analysis, for example, are the unidentified writings generally referred to as the question document. So if they were testifying in court, they would refer to the Ramsey ransom note as the question document. And now they're trying to decide who wrote it, who it belongs to. Writings prepared by a person in the past in the normal course of business are referred to in the field as historical writings or course of business writings. In contrast, writings prepared on request for the purpose of comparison are referred to as request exemplars. And we know that Patsy provided about 5 or 6 of these. Ideally, a handwriting expert should consult the original unidentified writing, not a copy, to increase the reliability of her assessment. The most reliable method of forensic document examination occurs when an examiner compares both historical writings and request exemplars to the question document. The recognized method for forensic document analysis occurs in several important steps. Now, I just want to say that although they're using big language here, it's pretty common sense just to say, well, here's the ransom note. Well, let's look at Patsy's writing where it's natural, and let's look at the exemplars that you've got. Whether you want to use scientific language or not, it seems pretty straightforward what to do. Anyway, this is legalese, and this is how, as I say, they were able to turn water into wine. They were able to say, oh, no, an intruder wrote the ransom note. In other words, someone whose handwriting we were never able to match wrote the ransom note. Oh, that's great. So they go on to say the recognized method for forensic document analysis occurs in several important steps. First, the expert determines whether a question document contains a sufficient amount of writing and enough individual characteristics. So do you think the question document 3 pages worth did? After determining that the question document is identifiable, the expert examines the submitted handwriting specimens in the same manner. If both the question document and the specimens contain sufficient identifiable characteristics, then the expert compares those characteristics often through the use of a chart. For example, the slant of the writing, the shapes of the letters, the letter connections, the height of the letters, the spacing between words, the I dots, the T crosses. They are all aspects of handwriting that can be used for comparison. Next, the expert weighs the evidence, considering both the similarities and the differences, and determines whether or not there is a match. Ignoring differences between characteristics is a frequent cause of error in handwriting identification. Similarly, dismissing differences as merely the product of intentional disguise is another common mistake made in the analysis. And I think that is quite interesting, is that this whole idea of dismissing differences as the product of intentional disguise, well, it does seem like the Ramsey ransom note was intentionally disguised. So who is going to know which differences to dismiss? In addition, an examiner should not know the identity of the comparators and should consult more than one comparator to increase the reliability of his or her analysis. Then, in addition to a recognized methodology, there are some accepted standards that should be employed when engaging in handwriting analysis. One standard is that the genuineness of the historical writing must be verified. I'm not really going to go through all of this. It's just the same stuff. It's fairly straightforward. We go now to page 43. And don't see anything here really worth mentioning. Plaintiff contends that modern handwriting analysis literature also views significant similarities as strong evidence that in some instances can outweigh an unexplainable difference between the writings. And so we go on and on and on. It just goes on and on and on. Page 45, they're still going on about it. And then eventually we get to point C, background and qualifications of the plaintiff's experts. And basically the bottom line is that they decide to ignore Sina Wong's testimony because they don't feel that she has the right credentials. So they say the court has concluded that a proper expert may assist a jury in the comparison of handwriting. Defendants assert that the plaintiff's experts, especially Ms. Wong, lack the necessary credentials. And then they say the court agrees with the defendants that Wong is not qualified to provide expert testimony. The court, however, finds that Epstein is qualified to present certain expert testimony in this case. What I think should have happened here, and it's just my opinion, but I think if the judge was fair and I think the other word might be conscientious, or I'm not quite sure, just responsible. I think a responsible ruling would be to say, okay, look, there's a problem with your experts. Can you go and get some other experts that we can all agree are qualified, right? I don't think it's fair to say, and I might be wrong that it's the role of the court to do this, but I don't think it's fair to say we're going to accept the assessment of one counsel's experts on the basis that we've thrown out the testimony of the others because they're not credible, right? I'm not quite sure what the law says about that, but I have seen in the past where I was at trial and I think they threw out the testimony of an expert who basically was trying to give an opinion, an expert opinion, on the psychology of the defendant, and it amounted to usurping the powers of the court, if that makes sense. In other words, what the judge said to the prosecutor, to the defense counsel, the judge said what is being presented amounts to usurping the power of the court. And what that basically means is that the expert was basically saying, I'm telling you what to think about the thoughts of the defendant. In South Africa, we refer to them as the accused. I'm telling you what to think about their thinking. And there's a point where the judge or the court or the jury needs to consider the evidence, and they've got to decide what to make of it. And you can't actually have an expert telling you what to think about certain evidence. And sometimes I think counsels come perilously close to doing that, because of course they are trying to influence the decision either way. So anyway, they say the court does find that Epstein is qualified to present certain expert testimony. So they're also limiting his role. Now I'm just saying, I think what would have been proper in this case would be to say, okay, go back, get some other experts that we can all agree, and then we'll decide. And ultimately what happened here is you throw out experts' testimony because you feel they're not credible because of accreditation and whatnot. That's not really a basis for accepting the other side of the equation as far as I'm concerned. Anyway, you go on. She says, Mr. Epstein is a forensic document examiner who has served as the past president of the American Society of Question Document Examiners, is a registered member of the ABFDE, and has authored several authoritative texts in the field. He has a Bachelor of Science in Criminal Justice from the University of Nebraska, a Master's of Forensic Science from Antioch School of Law, successfully completed a 2-year resident training program in the forensic science of question document examination at the U.S. Army Crime Laboratory in Fort Gordon, Georgia, and has trained with the Post Office Identification Laboratory. Plaintiff notes that Mr. Epstein has appeared in 200 cases over a 30-year period, having examined thousands of documents, has established question document laboratories for not only the U.S. government, but for those of Eastern Europe and the Philippines as well. What's amazing is, despite Epstein's qualifications, they still decide to limit what he can announce or pronounce his expertise on, right? It really just goes on and on. Epstein has taught forensic document examination at the George Washington Graduate School of Forensic Sciences, the Federal Law Enforcement Training Center, and in programs offered to the United States Army criminal investigators. The court concludes that Mr. Epstein's background constitutes sufficient qualifications to allow him to testify. Right? Then they say, in stark contrast to Epstein, Wong has never taken a certification exam or completed an accreditation course or been an apprentice to an ABFDE certified document examiner. She does, however, claim nearly 10 years of experience in the field. I mean, doesn't that count for something? And that is one of the stipulations they say is, do you have experience in the field? I mean, she was employed in some capacity. Doesn't that count for anything? She, however, is not a member of the ABFDE, the sole recognized organization for accreditation of qualified forensic document examiners. I can say in terms of myself, when I worked at a newsroom in Johannesburg, people wanted to know, are you a journalist? And I was actually asked this face-to-face by a couple of people there. Are you a journalist? In other words, so I guess what that means is, did you study journalism, right? And I think they could have asked my brother the same question. Are you an artist, I guess? Did you study art? And he studied art on his own time, and he became a full-time artist. Not anymore, though. I never studied journalism, but I committed acts of journalism my entire life. Does that mean, because you didn't study it, that you don't know anything? And I often get that criticism. I get the criticism of, well, what are you an expert on? And I would say, after writing 100 true crime books, writing not just one book, but a dozen books on several cases, a dozen book on Oscar Pistorius, half a dozen book on Jodi Arias, a dozen books on Chris Watts, it does actually make you an expert on the case. And I often come across experts that really don't know what they're talking about. But in terms of credibility, often the only way to get credibility is with some sort of qualification next to your name. Well, because you've got that qualification, you're credible. Doesn't really matter what you say. That qualification, that label, confers credibility. And so you have Sina Wong. She's the former vice president of the National Association of Document Examiners, but that's not good enough for them. The defendants note that this organization does not meet ABFDE certification requirements. It's just a stupid argument as far as I'm concerned. They found something that she doesn't meet, but she meets other things. I don't know, I just find it strange. She has no permanent office and has no membership requirements other than the payment of a fee. Wong herself admits that NADE does not require specialized training or experience for its certification. Finally, even Epstein, plaintiff's other expert, and this is why I say I feel like the prosecution was erratic, was disorganized, because you even have their own expert, right, the plaintiff's own expert, Epstein, testifying that Wong is not qualified to render opinions in this case. And I mean, you've just shot yourself in the foot. Accordingly, the court concludes Ms. Wong is not qualified to provide reliable handwriting analysis in this case. Then on page 48, it deals with the reliability of Epstein's testimony. So now this is the bottom line. Are you going to accept the other expert's testimony? You've already gotten rid of the one expert. You flushed that testimony down the toilet. Now you've got one expert left. What's going to happen? So she says, although the court has concluded as a general matter that Epstein is qualified to testify as a forensic document examiner, it must still determine the parameters of his expertise. So now they say, okay, well, you are an expert, but we're only going to let you express your expertise in a limited area. Okay, so they've already limited what he's going to say. Then they say, specifically, Epstein claims that he can state with absolute certainty that Mrs. Ramsey is the author of the ransom note. And so this is what he gets criticized on. You can't say you're absolutely certain. And so because he said that, now that has now challenged his credibility. How's that? The court as gatekeeper must therefore examine the methodology that he puts forward in support of such a categorical conclusion. So because he's made such a categorical statement, now he's got a lot more kind of riding on it. He's got a lot more pressure on him to make sure that he's never made mistakes in the past, kind of thing. So he says, first, Epstein states that he used the standard methodology of forensic document examiners when assessing the ransom note and Mrs. Ramsey's writing samples. Now, I don't know why they're not reverting to those original jargon, Anyway, he initially determined that he had a sufficient amount of handwriting by Mrs. Ramsey to allow an examination. He then proceeded to examine the submitted materials for similarities and dissimilarities. After conducting the examination, he then determined that the original writing matched to a 100% degree of certainty. Finally, he consulted other forensic document analysts who approved of his methodology and results. So I think that is quite useful, that he spoke to other document examiners and they found the same thing. Then, defendants moved to exclude the testimony of Epstein because they assert that the methodology employed does not meet the accepted standards. This is page 49. In particular, defendants argue that Epstein's opinions are not reliable because he did not consult the original ransom note. And I'm not going to take it much further than that, but that is how they ended up excluding all of the experts of the prosecution. And what are you then left with? Oh, Patsy Ramsey didn't write the ransom note because there aren't any experts that you can use. You can't use any of the arguments from the prosecution experts. Quite easily done. What is quite interesting is Epstein kind of argued back and he was saying, copies are of a higher quality today than they were in the past. But it was all really water off a duck's back. They weren't really going to listen to him. He goes on to complain that the defendants refused to provide original exemplars despite plaintiff's discovery requests. So, you've really got to ask yourself, if the defendants, being the Ramseys, had nothing to fear, if they were so confident that Patsy didn't write the ransom note, why not just provide the expert with the ransom note? And I think part of the answer is to make this legal argument, which they ultimately won. I just think it's not very sophisticated, and this is my opinion. I just think it's not very sophisticated of the judge not to see this as a ploy and instead to prefer the argument of the defense. So it concludes saying, in short, the court is satisfied as to Epstein's ability to testify concerning perceived similarities and differences, but at the same time, the plaintiff never sought a motion to compel such production. So because he never, I don't know whether he was supposed to subpoena it or whatever, but because he didn't do that, again, a failure from the prosecution lawyer, the court sided with the defense. So at the end of the day, what Judge Carnes decided was, she says, accordingly, the court concludes that while Epstein can properly assist the trier of fact by pointing out marked differences and unusual similarities between Mrs. Ramsey's writing and the ransom note, he has not demonstrated a methodology whereby he can draw a conclusion to an absolute certainty that a given writer wrote the note. So it's quite clever. What they're basically saying is, because he didn't have the original, he can't make the statement that is absolutely certain. Can you see what they're sort of getting at? They're basically saying, because he didn't have the original ransom note, and he says he was absolutely certain that Patsy Ramsey was the ransom note writer, this then undermined his credibility and the confidence of the court in his credibility. And so they conclude at the bottom of page 53, in so holding, the court does not rule out the possibility that upon a proper showing, a handwriting expert might be able to demonstrate reliability sufficient to allow testimony concerning his conclusions. The court simply holds that Mr. Epstein has not made that showing in this case. Then we go to page 54. I'm just going to skim through that. It's just really referring to a lot of case law. And then that brings us to summary judgment motion. As noted, plaintiff's complaint asserts both a libel and slander claim. Plaintiff asserts that defendant's mention of him as a suspect in the book is a knowing falsehood because defendants knew that Mrs. Ramsey actually committed the murder. So in order to make the claim of malicious defamation, if they could prove that Patsy Ramsey wrote the ransom note, or prove that it was very likely that Patsy Ramsey wrote the ransom note, then it would give credibility to the claim that they had maliciously slandered them. But because they didn't succeed in that, the claim of malicious slander falls away. In tomorrow's episode, we'll pick up at the bottom of page 57, the section dealing with the libel claim. In the meantime, I want you to think about the question, do you think the Ramsey case is currently being investigated? Do you think it is actually, because it's an active investigation, do you think it is actively being investigated or not? Yes or no? Let me know what you think about that in the comments. Just a final thing that I want to draw your attention to. On Patreon, I've conducted a poll. I've asked my patrons which audiobook they would like me to do next. Bear in mind, I've written about many different high-profile cases. I asked them to vote on Night Before Christmas by Scott Peterson, The Mysterious Mistress and the Confession, that's a book on Chris Watts, Treachery about Casey Anthony. I've asked them, do they want me to narrate a book on the Everest disaster, or the Amanda Knox case, or Jodi Arias. And the most votes that came in, bear in mind that I've just completed a narrative on the JonBenet Ramsey case. They've asked for another narrative on the JonBenet Ramsey case. So the most votes were for that. The second most votes were for a audiobook on the Chris Watts case. And the third most votes were for a book called Audacity on Jodi Arias. Obviously, I will probably eventually get to all of these books in due course, but I want to be doing these books at the time that my patrons want them the most. So more than likely, I will be narrating another JonBenet Ramsey narrative. And after that, and I think this will bring us closer to the 3rd anniversary of the Chris Watts case, another narrative on the Chris Watts case. This weekend, I might be doing a live dealing with some of the insights that came out of The Craven Silence, the first book of the trilogy. Okay, I'm not going to take it further than that. Thank you for listening, and I'll see you guys next time for episode 14 in the Khan's Order series.